Agreed to. I call the Honourable Marianne Street.
Mr Speaker, thank you very much. I rise to speak to the third reading of this Trademarks, International Treaties and Enforcement Amendment Bill, wishing to make a couple of comments because in the time that between the introduction of this bill and its passage now, there's been a great deal more discussion about the importance of trademarks and intellectual property, particularly in the context of the Trans-Pacific Partnership Agreement negotiations. And I want to touch on that for a moment, Mr Speaker, because it is pertinent to the purposes and the functioning of this piece of legislation. Mr Speaker, this bill was introduced on the 8th of September 2008 under a Labour government. We are supporting this bill. It was originally ours. Its first reading appeared on the 7th of April in 2009. After that, of course, it was referred to the Foreign Affairs, Defence and Trade Select Committee for consideration, and we on that committee reported back on the 15th of September 2009. So within about 5 months, we had received submissions, we had deliberated, we had taken extensive official advice because there were some tricky pieces in this legislation, and we had reported back to the House. In our report, Mr Chairman, on page 2, as it is reported back to the House now from the Foreign Affairs, Defence and Trade Committee, under the Commencement Clause section, it says there is a discussion on a number of clauses that were required to be implemented by order in council. In other words, regulatory items that would not come before Parliament. And they were largely procedural matters. But we went on to say that having considered whether or not these things should be implemented by order in council or before the full Parliament, we accepted that there were valid reasons for commencement by order in council, and I quote, Mr Speaker, "We urge the Ministry of Economic Development to implement all aspects of the legislation expeditiously." Expeditiously. That was the 15th of September 2009. It has been sitting 2 years, almost to the day, Mr Speaker, before it started to get its second reading. Its second reading came in on the 16th of August of this year, 2011, under urgency. So why did the government suddenly wake up and think that this bill, which had been languishing on the government's order paper for 2 years, having been urged by the Select Committee to be implemented expeditiously, would need to be resurrected under urgency and then put through 2 years later? So we have no explanation at any time from any of the members opposite or the Minister in charge as to why a 2-year delay has been occasioned in the course and procedure of this bill. But Mr Speaker, the other point that I want to make is that this trademarks bill has three particular purposes. One is for New Zealand to sign up in a timely way, but here we go, 2 years late, to 3 international trademark treaties. Its purpose is also to enhance the existing enforcement provisions in the Trademarks and Copyrights Act in order to address issues of counterfeiting of registered trademarks and the piracy of copyright protected works. And there are a number of technical issues as well that are to be addressed in this legislation. But Mr Speaker, there is a different colour a different complexion now being cast on the issues of intellectual property because of wide-ranging debates on the Trans-Pacific Partnership Agreement, particularly chapters in the negotiations to do with intellectual property. We need to be very careful that everything we do around intellectual property protects the creative industries and those who wish not to have their creativity pirated, but at the same time allows for opportunities for trade. And I would ask this government, in the short time it has left before the election, to ensure that this legislation meets the changed climate around intellectual property. We must not be in the position, having passed what I think is basically good legislation, of trading away our right to copyright protection and trademark protection under the Trans-Pacific Partnership Agreement. Now, we know, Mr. Speaker, that intellectual property questions are being raised routinely and vociferously by non-governmental organisations who have a right to be involved and have a right to be heard in the process of negotiating the Trans-Pacific Partnership Agreement. There are real concerns in this area, and New Zealand needs to be cognisant of them. We need to be sure that we are not trading away, either consciously or unconsciously, anything that undermines our sovereign rights as a country. This legislation brings us into line with international treaties, and that is a good thing. The Madrid Protocol, the Singapore Treaty, these things are important, and we need to be consistent with them. But let us not ignore the fact that the narrative is changing around these issues. This is not an area of debate, Mr. Speaker, that is cast in stone. It is not an area of debate that once the treaty is signed, that is the end of it, that's the full stop. This is a dynamic discussion. Issues to do with intellectual property are being revisited daily by countries apart from New Zealand, not just New Zealand, and not just our non-governmental sector, but being questioned by academics around the world, and we need to be sure that nothing we do in the passing of this legislation or in the signing of any free trade agreements in the future undermines New Zealand's sovereignty and undermines our right to protect trademarks, creative products, and industries that can trade in the knowledge sector, not just in the commodity sector. Mr. Speaker, the bill is okay as far as it goes. The bill does what it needs to do in technical terms, but can I just alert this House to the fact that these discussions are not over. Thank you, Mr. Speaker.